basic structure of the Constitution by challenging the independence of the judiciary, giving the executive a big say in how the judiciary is appointed. That is a very heated argument on how much of a role should the executive play in the appointment of the judiciary, and it seems that the Supreme Court has decided in favour of the petitioners who had challenged the constitutional amendment as well as the NJAC Act. That's the news coming in right now. There is or was, from what I understand, and I can tell you that Twitter and social media is very alive with this, because every lawyer in Delhi was in that courtroom this morning or continues to be, and I'm told that a prayer for a reference to a larger bench has been declined by the 5-judge bench. The collegium system will continue. Now, essentially, the collegium system was about the CJI and 5 senior most judges of the Supreme Court deciding on appointment of judges to the higher judiciary, that is to the High Court and the Supreme Court. That was the collegium system. It was a system that was put in place in the 90s. It was put in place by several landmark cases. They're called the first and second judges cases, but more importantly, it's the second judges cases which said that, selection to the higher judiciary should be made by senior judges themselves. Originally, it was supposed to be a panel of 3. The third judges case in 1998 expanded it to a panel of 5. So it was 5 Supreme Court judges, including the Chief Justice, and these are the senior most judges, who formed the collegium and who appoint judges to the Supreme Court. We're waiting to get some comments coming in. There we have it.
It has to go. Sir, what has been the verdict today from the court?
That the amendment has been declared unconstitutional. Means the old collegiate system will continue.
So what were the observations that the court made in favor of taking this?
In a historic judgment today, by the Constitution Bench of Supreme Court of India, led by Honorable Justice J.S. Keha, the Honorable Supreme Court has declared 99th Amendment of the Constitution seeking appointment of Judicial Commission as unconstitutional. The ground for unconstitutionality is that it violates the basic structure of the Constitution. As per the basic structure of the Constitution, independence of judiciary is a part of the basic structure, and it interferes with the independence of judiciary, and thus the basic structure cannot be allowed to be tampered with. So on that ground, the Constitution Bench has declared the amendment unconstitutional. The old system of collegium system, where the senior most judges will choose the judges, will continue. That has been restored.
So what has been the how many judges were for it, or was it in unanimity?
It was the majority judgment. Number they were still reading when we came.
Okay.
So
yes.
Your name?
Dr. Sidharth Sr Advocates, Supreme Court.
Okay.
Yes. Yes. आज एक बहुत ही ऐतिहासिक महत्वपूर्ण फैसले में संविधान बेंच ने, सुप्रीम कोर्ट की ने, जिसमें जस्टिस के
All right, there you have it. Sidharth Singh, an advocate in the Supreme Court, they're detailing what the majority decision in the Supreme Court was today. We have CNBC TV 18's Ashmit Kumar right there on location to give us all the details, as also a panel of legal experts starting with Supreme Court counsel HP Ranina. Ashmit, I'm going to come to you first. The quick details, did we have any dissenting views? Ashmit, can you hear me?
Right, so what we can pick up at this point is that it appears to be, at least in the initial stages, 4-1 judgment where 4 judges have concurred with 1 dissenting view. Of course, the broad contours are already available to us. The NJAC Act and as well as the constitutional amendment have been held to be constitutionally invalid. The prayers that the government has made, with respect to reference to a larger bench, that has also been denied. And as of now, what we have is that the bench has clarified in very clear terms that we will be now reverting back to the collegium system, thereby finally giving some clarity on the issue of judicial appointment.
All right, Ashmit, I know I can hear in your voice what a crazy morning this has been. So I'm going to let you get back to trying to get us some more details. Come back to us as soon as if you have some more details of what judgments are being read out in court right now. But let's go to HP Ranina. Mr. Ranina, would you say to some extent that the independence of the judiciary has been upheld today? Or are you amongst those critics of the collegium system who call it too opaque and transparent, and therefore it was the time to change?
No, I think the Supreme Court has gone by the basic theory judgment of Keshavananda Bharti, which is that the judiciary being one of the pillars of the Constitution, it is a basic structure. So no parliamentary law can amend the basic structure of the Constitution of India. And since the judiciary has to play an independent role, they have said that the collegium system, which has been functioning for the past many years, has worked fairly well, and there's no need for the parliament to interfere and to impose on them the National Judicial Appointments Commission. And that is why they've struck it down as being unconstitutional. So I think it's just a reflection of the basic structure theory of the Constitution that Parliament cannot amend the law which will affect the basic structure of the Constitution. And this is why the judgment has come, the majority judgment.
Okay, I know there are different readings of the Constitution when it says that the President can appoint judges in consultation with the CJI, but I won't get into the legal debates, and so Supreme Court has already ruled on it. What I'd like to understand, Mr. Ranina, here is the relevance of the fact that the government asked for a reference to a larger bench. This was a bench of 5 judges. We've seen in the second judge's case a bench of 9 judges. The government has asked for a larger bench, and that request too has been turned down today. Do you see any scope for this to be litigated or argued any further, or will this be the final conclusive decision?
I think this will be final and conclusive, because what else can the government do? If the government's plea for a 9-member bench has been turned down, well, that's the end of the matter. There's nothing that can be done by the government anymore. So I think this is going to be a conclusive judgment, because just because the judgment goes against the government doesn't necessarily mean that a larger bench should be constituted. And therefore, I think this will bring closure to the issue.
Okay, we are still awaiting details of what the judges or, what details or specifics of the NJAC that the judges or the bench found unconstitutional. But I do want to put this question to you. Do you see any scope for further change in the collegium system? Because this bill, the NJAC bill, which suggests that judicial appointments be made by a Judicial Appointment Commission that has 3 judges on it, the law minister and 2 eminent persons from civil life. This was the product of both the UPA and the NDA government. It got unanimous backing from the parliament. So the political class is unlikely to back down at this point in time. They will want an improvement on the current collegium system. Is there any option? Do you believe a revised act or a revised constitutional amendment might be a middle path?
Well, they will try. If the parliament is determined to have their way, they will certainly try. They will come up with some other commission which will be more acceptable to the government, to the judiciary. I think ultimately what the government will try to do is to make sure that they will come up with something which is hereafter acceptable to the Supreme Court. And until then, the collegium system will continue. So let's wait and watch what is the new amendment, what's the new law that they want to bring in to make something which is more acceptable to the judiciary. And I think the government will keep on trying, maybe not now, maybe after 2 years, maybe after 3 years.
All right, Mr. Ranina, I appreciate your comments this morning. We've got Prashant Bhushan speaking right now. Let's listen into him as well.
कि रीढ़ की हड्डी है न्यायपालिका की स्वतंत्रता, तो एक बहुत ही अहम फैसला सुप्रीम कोर्ट से आया. The Supreme Court today, in a very, very important decision, has quashed the National Judicial Appointments Bill, which had been brought through a constitutional amendment, by which the present collegium system, by which the senior judges of the Supreme Court select judges, that was sought to be replaced by a commission in which there was a law minister, 2 eminent persons selected by the government, plus the leader of opposition, plus the Chief Justice, and 3 senior judges. The court has held that this National Judicial Appointments Commission, in which the government would get a substantial say in judicial appointments, interferes with the independence of the judiciary and therefore has been declared to be unconstitutional. From now on, the collegium system gets restored, by which the senior judges select the judges, but as to whether and what the court has said about the need for transparency in the collegium system, we don't know. We'll have to read the whole judgment before we understand Whether and if
does this
so, what?
automatically revive the old collegium system?
Yes,
because they said it is dead and buried. The IG has
No. That revives the old collegium system for the time being.
Sir, is it a unanimous?
All right, there you have it, Prashant Bhushan. So essentially, Nigel, you know, there were pitched debates on both sides, and let me give you a sense of the luminaries in Supreme Court that argued for and against, right? So you had Fali Nariman, Prashant Bhushan, Anil Diwan, Ram Jethmalani, Arvind Datar, all arguing against the collegium system. You, of course, had Mukul Rohatgi, who is the law officer of the country, arguing in favor of the NJAC. But along with him, you had K.K. Venugopal, one of India's best-known constitutional experts, and Harish Salve, both representing different states and arguing in favor of the NJAC. So this was the level of argument that took place in the country. Several Supreme Court lawyers have made their views heard in this matter in some way or the other. And, you know, it eventually came down to the independence of the judiciary and how much of a say the executive ought to have in the appointment of judges in both the High Court as well as the Supreme Court. The NJAC, while it visualizes a panel of 6 people appointing those judges, and that panel is embedded in the constitutional amendment, many aspects of the selection process of judges was left to the Act, the NJAC Act. And one of the big fears was that acts can be changed fairly frequently by Parliament. If you don't enshrine it in a constitutional amendment and make very clear what the selection processes will be, then you're leaving this up to the whims and fancies of the Parliament. Some might argue, why not? Why should there not be parliamentary accountability, you know, of the judiciary? But others believe that too much political interference, you know, in the judicial appointment system would lead to an unindependent judiciary, and that is against the basic structure of our constitution, which calls for the separation of powers between the executive, the parliament, which is the legislative body, and the judiciary. So that's what this big debate was about. It was a critical debate for the future of the judiciary, because even those who have argued in favor of the collegium system criticize many aspects of the collegium system, saying it's very opaque. Judicial appointments are made by senior Supreme Court judges on a variety of bases which are ad hoc, arbitrary, unexplained. So everybody seems to want reform of the collegium system, but do you want it to go all the way up to the NJAC? Well, the Supreme Court seems to have said no, the NJAC is unconstitutional.
Well, Menka, but we'll also have to wait by for further details, because as you were saying, both the teams are fairly strong, and you said both the governments as well were in favor of the NJAC.
Well, this has found, I mean, this was one of the Constitutional Amendment Bill and the NJAC Bill were passed very quickly by Parliament. Sure. I can tell you that. So it had support from across the political class. It's not a bill or an act or a reform that belongs to any one government.
All right, so they're unlikely to go down without a fight, I'm guessing. So we'll have to still wait by for all those details and then see what's the future goes.
Well, that exactly is the case. We will watch for the fine print, you know, later this afternoon to find out on what grounds and with what specific intent the Supreme Court has considered the NJAC unconstitutional, and therefore what happens from here on. I'm sure the government will also make its view known on whether it attends or it expects to amend or you know, let's say reenact a new constitutional amendment or a new NJAC bill that meets the concerns of the Supreme Court bench and therefore might be a more acceptable solution. So that's where things stand as of now. I do believe that we have Justice Sodhi with us online, if we can get a view from him. Justice Sodhi, good morning. Can you hear me? Yes. I do want to know what you make of this Supreme Court decision, sir.
See, for the Supreme Court decision, it's quite clear that they've struck down this the bill, namely that the collegium system still has the rule of the day. I mean, this may be the first round in this battle, but I don't think the Parliament is going to buckle down that easily, and neither is the Supreme Court. But all said and done, all we have to see is the independence of judiciary. We cannot allow it to be compromised. At the same time, we cannot allow it to become arbitrary. So in both cases, some via media will have to be found so that the judicial system is carried forward and not made to suffer on one account or the other.
Justice Sodhi, do you expect that this might lead to some sort of paring down of what was proposed in the earlier constitutional amendment and the NJAC Act, continued efforts by the government to change the collegium system?
You see, we must understand first, the first thing is that the collegium system came about by what can be said is a judicial hijack.
Right.
Now, the judiciary hijacked the constitution in its favor, and therefore, in the judge's case, therefore brought about a system which suited them, or well, they thought was the best. Obviously, that has not turned out to be the best, and there are problems in that system as well. Now, the court, having struck down this part, surely says that it is unconstitutional. Now, how it is unconstitutional, we will have to read the judgment itself. But I do not think that the Parliament is going to step down that easily. I don't think so.
All right. So what do you expect could be the next steps? Because I'm told today the government asked for a reference to a larger bench, and that too was turned down by this 5-judge bench of the Supreme Court. So how do you expect, from a legal process point of view, this to proceed here on if the political class is insistent that the collegium system either has to go or change?
You see, ultimately, all said and done, you see, Parliament is supreme. We can't undermine the authority of the Parliament. But at the same time, we have a basic structure which says that the judiciary must remain independent of these pulls and pressures. Now, some kind of a mean will have to be arrived at so that independence of the judiciary is not compromised, but at the same time, the ball really lies with the Parliament. We cannot allow either judicial dictatorship, or we cannot allow the Parliament to compromise on its independence. So either way, both is it's important to see. Now let's see what happens hereafter.
What do you expect, sir, will happen? That's what I'm trying to understand.
I think the Parliament is not going to buckle down, and neither is the Supreme Court. It's going to be very interesting to see how this battle goes on from here onwards.
I suppose now appointments to the High Court and the Supreme Court were, in a sense, in suspended animation while this case was going on. If I understand correctly, those will resume under the old collegium system, sir, because there are several judicial positions vacant awaiting attention.
Yes, I suppose the collegium system will now revive itself and appoint and fill up all the vacancies. That again, you see, it's a difficult proposition to answer, because is the Parliament going to allow that? I mean, this is something we will watch and see. How far the Parliament is ready to give up its jurisdiction and power.
But how will they stop the collegium, or how will they stop the appointment of judges from here on, sir?
Well, Parliament has powers. They can pass yet another bill. They can modify this. They can even they could, in one sense, even pass a resolution against the collegium system. After all, it is Parliament.
So you expect that we're in for a pitched battle here on?
I hope not, but yes, I can sense it.
Justice Sodhi, we appreciate you joining us this morning. We do have now with us Sidharth Luthra, well-known Supreme Court counsel and a former law officer for the government. Mr. Luthra, thank you very much for joining us this morning. This is a fairly historic day when it comes to the issue of the independence of the judiciary. But I'm very interested in knowing how you think this is going to resolve itself from here on, because all the views we're getting this morning is that neither the Parliament nor the judiciary are likely to back down.
I must tell you, in the judicial history of India, this will be known as the third judge's case. It's a landmark decision. There was a lot of noise being made from time to time that the system needed to be looked at, the system needed modification, the collegium system was opaque. So two things have happened, as I'm given to understand. One, of course, the Supreme Court believes that the amendment that was sought to be brought was not in a form which was palatable, acceptable to judicial independence, and it was an interference on the independence of judiciary, and therefore it's been struck down. However, I'm also informed that in November of this year, the Supreme Court will carry out further hearings to find methods and means to improve the system, which is also a very good sign, because I believe that balance is being sought to be found by the court. And today, in the times we live in, it is very important that judicial independence be maintained. And I think to that extent, it's a landmark decision. very important in the history of India, very important for people's fundamental rights, and a great way forward. Of course, the court has coupled it with the proposed November hearings, and I think that balance will provide an equilibrium which will help judicial independence, as also protect rights of the system and make for a better system.
Mr. Luthra, could you share with us any more details that you may have about these November hearings in terms of who will they consult, how will they take place, and how will that feed into the collegium system, which in fact, as you pointed out, was set out by the second judge's case decision by the Supreme Court?
Yes, of course. Right now, the details are a little sketchy because we've not got a copy of the judgment. Once the judgment is out, we'll be able to find out what the details and what are the aspects that the court wishes to look at and the nature of hearings that are to be carried out. We'll have to wait for the copy of the decision for that.
There are many who have criticized the current functioning of the collegium system and who believe that it is time to change. Maybe they don't believe that the NJAC is the best solution, but they do believe that it is time to change. Would you be in that group of people or camp, if I may call it that?
My belief is that the collegium system needed improvement, needed change. There were questions that could be asked about its functioning and legitimacy. But at the same time, I don't think the NJAC was necessarily the way forward because the NJAC left a lot of ambiguities. It left a lot of areas where there could be misapplication of the law. And therefore, I think, if at all, if the government so chooses, they may want to relook at how they want to bring in the legislation. But for now, the collegium system is here and it's here to stay.
So you understand how governments work very well. You have been a law officer in the past. I do want to ask you what you think the government's response will be from here on, because this NJAC and the constitutional amendment that fathered it are a product of successive governments. They don't belong to any one political party. They seem to have found unanimous support from within the political class. And so do you believe that the government will wait to see how the Supreme Court reforms its own process? Or do you expect that we will see a pitched battle from here on? The government will try again to legislate or modify the constitutional amendment or set or pass a new NJAC Act?
I would think, and I would assume more likely than not, that that any government would perhaps try and bring out a modified form of the NJAC. But it would be important for the government to heed and listen to the voice of the Supreme Court, to read this judgment and understand what the court has said, and that should be contemplated or considered before they propose any amendment in the future. I think it's important that the judiciary is independent, it is strong, and it maintains a sense of equilibrium in this country, because that is important for every citizen's right. In the times that come, that is the only bulwark of freedom that we have. Governments come, governments go, governments decide, governments legislate. But an independent judiciary has protected this country for the last many decades, and it will continue to do so in the future.
Okay, so we do now have news that on November 3rd, the Supreme Court will hear government's views on improving the collegium system. So there is the slightest of chance that both sides may come together to come up with a better system that does not compromise the independence of the judiciary, unless, of course, the government insists on trying to litigate this further. And that's my final question to you. Their effort to get this referred to a larger bench was turned down today. Do you think there's any chance that they might succeed in getting this referred to a larger bench? Is there any other process or way in which they could do that in the Supreme Court?
I think the only issue is to seek a review of this judgment, and as and when that is filed, that will have to be considered on its own merits if they have a ground for review. But meanwhile, my belief is that it would be perhaps more appropriate to address the matters in the course of the November hearing to try and come out with a better system. After all, when there is introspection on the part of the court, when the court believes that introspection is necessary and the matter needs to be reconsidered, keeping with the concerns raised by government and from within the system, I believe that if the two sides were to further the cause of the Constitution and further cause of fundamental rights, we would go a long way in assuring a more active democracy.
A final question then, I'm just wondering if, in a case of a review, I understand so far that in matters like this, the chances of a review overturning the earlier decision are virtually slim to none, right? Because the same bench would look at the review. So it would be fair to say.
I don't really think so. I think that was a view we used to hold much earlier. But increasingly in important matters where cases are being made out, the court has reviewed. If you remember the NAS Foundation case, the review was considered. There are other cases where reviews have been considered. In the Bhopal gas tragedy, Bhopal gas case, after about 19 years, even a curative petition was entertained. It was finally after a detailed decision turned on, but it was considered. So it's not that the court is not willing to relook at it. The issue will be, does the decision create any ground for review? And if it does not, then of course the review is not to be entertained. But if on the other hand, there are scope for consideration that there are errors which require errors apparent on the face which show that there may be some scope for a review, then I'm sure the court will not be reluctant to hear it and reconsider it, if at all such a case is made out.
So you're saying there is a possible chance of a review being entertained, or even a curative being entertained at some point. This might not be the ultimate word, it could be the penultimate word.
I must clarify this. You see, the question is, it is the government's decision, or the parties who are appearing, or others, to determine whether they want to seek a review or not. So the first issue, the government will have to make up its mind, is this a case which they believe is fit for review? And the second level will be, the court will have to determine whether those reasons are legitimate or not. And that determination is, I believe, a little way off, although there's a 30-day period for filing of a review. But right now, it has to be done with a serious amount of deliberation after the judgment has been read, analyzed and understood.
Fair enough, Mr. Luthra. We appreciate you joining us this morning, and we look forward to speaking to you once we have the fine print with us again. That was Sidharth Luthra taking you through his views on this issue, a historic day, Nigel. Before I hand it back to you, to quickly summarize what has happened, the Supreme Court has held that the moving of judicial appointments to the National Judicial Appointments Commission is unconstitutional. The reasons for which we are yet to hear or read when we do get the fine print, but essentially it impinges on the independence of the judiciary, and hence the selection of judges to the higher judiciary will continue through the collegium system that was put in place in the mid-90s, and that essentially involves a group of 5 senior-most judges in the Supreme Court deciding on judicial appointments to the High Court and the Supreme Court. What happens next from here on? Will the battle between the government and Parliament and the judiciary continue? Well, as Sidharth Luthra pointed out, there's always scope for a review and a possible curative petition. Those are the processes that are laid down very clearly in the Supreme Court if a matter is to be taken further. So those two processes, if the government decides to use, are open to them. But more importantly, the Supreme Court itself has said that it will hear views from the government and hopefully other parties on how to reform the collegium system. And that hearing will take place on November 3rd, as we've just heard. So here is the judiciary saying, yes, maybe we don't have the perfect system, we should change it, but your system is not the right solution. So let's see how we can change this system. Let's see how that progresses. But for today and now, like Sidharth Luthra said, this is a historic day, probably will be remembered as the 4th judge's case, and a day in which the Supreme Court said that the independence of the judiciary is most important.
All right.